If you are someone who has a will or you die without a will and you leave any assets or minor children behind, you're going to have to go through what we call probate. And all that probate is taking your will to the courthouse and probating it, having a judge review the witnesses, the signatures, and appoint you or whoever else is involved who's ever been named in the will as the executor or executrix of the estate. If you don't have a will, you still go through that process and you get appointed what's called the administrator or the administratrix of the will. And you, along with us or your lawyer, winds up those affairs, pays any bills that have to be paid, sells any property that needs to be sold, takes care of working with the banks and the tax collectors and everybody else. It's called probate, and it's setting up an estate. Another time that we do this, if somebody passes away and they don't have a will, we set up an estate to pursue medical malpractice, police misconduct, or car accident claims. You have to set up an estate. It is the legal entity in which you have to operate. It's just like a corporation. It's considered a person. So, death is part of life. Every one of us are going to die. If you don't do proper estate planning, your estate is going to have to be probated, which means it goes through the court system. Another thing that's important is there's a 6-month period in Kentucky, for example, where your creditors can file claims against your estate for any money that's owed. One of the reasons why, and you can watch the other video here about trusts, is if you don't have things in your name and you have them in trusts and things like that while you're living, nobody can file claims against those estates. That's another myth, by the way. If your mom or dad die and they owe $100,000 to creditors, you do not have to pay off their bills. If you got any questions about estates and probate matters, email me at the address below and we'll take good care of you. Thank you.